one, the record, please. And we have court reporter, so I guess I'm not going to.
Right.
George Pino, parties announced.
Good morning, Your Honor. Laura Adams, Jonathan Borst on behalf of the state of Florida.
Good morning, Judge Howard Srebnick, together with Mark Shapiro, Ed Armelino, Janelle Gomez. On behalf of George Pino, also at counsel's table is our expert, Christopher Carentz, because I believe the state's expert is testifying this morning.
Okay, thank you. Mr. Pino, you raise your right hand. Swear from the testimony to the truth, nothing but the truth.
I do.
Thank you.
Thank you, Your Honor.
All right. We were all very busy over the weekend doing some work and research addressing the potential jury instructions, but I think the issue for this morning briefly will be to address the scope of what would be the next witness's testimony, and having to do with the testimony regarding the navigational rules.
Yes, Your Honor. Good morning again. The state's position is this. Number one, at no time will we ask the state's next witness, Paul Albert, any questions about whether, in his opinion, the defendant violated any navigational rules. So that's off the table. But because he has been an instructor for so many years in boating safety courses and, in fact, in training other Marine Patrol type officers about the navigational rules, and because it is the law that navigational rules must be followed, it was simply my intention to ask him to outline what the navigational rules are, and have him explain they are basically the quote-unquote rules of the road for those that are operating vessels. And then I was just going to ask him about a few of the navigational rules that I think are applicable to this case, specifically Navigational Rule 5, which mandates that, I'm sorry, Judge. Rule 5, which mandates that those operating vessels must keep a proper lookout. Rule 6, which mandates that vessels must be operated at a safe speed for the prevailing conditions. Rule 7, which provides that operators of vessels must take every precaution to avoid the risk of a collision. And Rule 8, which provides that operators of vessels must take every precaution that they can to avoid any kind of a collision. That would be toward the front of his testimony, Your Honor. And then from there, I will begin to go through his crash reconstruction analysis, the actual extraction of data from the SIMRAD or GPS devices, what his interpretation of that data means, etc. But at no time will he say that the defendant violated any of these 4 rules.
So let's talk generally, though, about, and this flows into the issue of the jury instructions as well.
I'm still having trouble hearing you.
This flows into the issue of the jury instructions as well. And I received the defense memo on this point. And do you want to just summarize your position, counsel?
Yes. So this witness is going to be, I guess, trying to lay the law down, which is the court's responsibility, of course. And so we've outlined our position with regard to that issue. The leading case we found was a case called Logan. And so we filed a pleading on that over the weekend, and we would ask that the court simply exclude all of this testimony about rules. Alternatively, there'll come a point in time where the court would, if it's admitting the evidence, give a limiting instruction on how to assess those rules, that mere violation of a navigation rule does not constitute recklessness or culpable negligence, and there are proposed jury instructions on those points.
Right.
and I understand what the state is saying is that in all events, if the court's going to allow the witness to testify, the witness will not be giving any opinions about violations of the rule, and consistent with the state's pretrial motion in limine, will not be asking the witness to give an opinion on whether the operator drove recklessly or culpably negligent, or give any opinion at all about the ultimate issue. So I'll be expecting that will be enforced. Stand by, Judge.
And that's really, the second point that you made, that's really the issue. While it will be over defense objection, I'm going to allow the witness to testify in general about navigational rules and the purpose of navigational rules. Under the circumstances of this case, but I am going to be very clear to the jury so they are not misled by information of testimony regarding navigational rules, ultimately the instruction of the navigational rules, because there is a violation of the navigational rule does not rise to the level of the type of recklessness by statute in order to find anyone guilty of a felony. And I was kind of playing around with different types of instructions, but I am going to be ready to give the jury a limiting instruction at the outset of the testimony, or at the point of the testimony. I guess it would be after he's sworn, and after maybe there's some initial questioning of the witness as to, once he starts to discuss navigation rules. So I'm actually both going to help me with that. I understand it's over defense objection, but I am going to allow testimony as long as the witness has been instructed that he is not to give any kind of opinion as to whether or not any navigational rules have been broken, and his interpretation of whether the conduct was or wasn't. Mr. Pino?
He will not, Judge.
Okay.
He will not.
So I couldn't hear that last part?
Whatever the conduct was or wasn't of Mr. Pino is not to give any kind of opinion or statement on the reasonableness of Mr. Pino's conduct.
And so he will not, the witness, be describing anything as, quote, inherently dangerous or anything like that?
No, that's
Correct.
not, that is not, he is not permitted to do that. He's going to provide the information, his knowledge about the information, and that should be the extent. Now, you've outlined 4 specific rules.
Yes, Judge.
Okay, all right. So there's going to be testimony in general about navigation rules.
Correct.
Rules of the road.
Yes.
And then maybe more specifically, but again, this is not, it has to be clear to the jury.
To that end, Your Honor, I know the court was on the bench. When I got the defense motion, I think it was Saturday evening, I took time yesterday to start working on it, but I wasn't able to finalize a response to their reply, and I did file an amended motion for a special jury instruction. And cutting to the chase, Judge, what I would say is this. The Logan case that the defense cites does not per se prohibit the jury from being instructed on, for example, in Logan, there were instructions about running a red light or running a stop sign, things that had happened well before the actual fatal event had happened. And in Logan, the court said that it is not necessarily, and they emphasize the word necessarily, error to instruct the jury on violations of safety statutes in a culpable negligence case, but that proper instructions which advise the jury how to use these statutory violations in evaluating culpable negligence are necessary. They then go on to cite with approval an instruction that was given in a 1972 North Carolina case, but essentially what the court wound up doing, and I quoted from that case in my response, that if the, An unintentional violation of a statute accompanied by reckless or probable consequences of a dangerous nature when tested by the rule of reasonable foresight is not such negligence as imports criminal responsibility. However, if the inadvertent, that is, or the unintentional violation of a prohibitory statute, which I would argue the navigational rules are, be accompanied by reckless or probable consequences of a dangerous nature when tested by the rule of reasonable foresight, amounting altogether to a thoughtless disregard of consequences or a heedless indifference to the rights and safety of others, then such negligence, if death proximately ensues, would be criminal negligence and the actor would be guilty of manslaughter. We talk a little bit differently now than in 72. So what I tried to do is take that language that was approved of in Logan, and this is what I propose for the court to instruct the jury regarding the navigational rules. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigational rules. However, a violation of any of these rules is not sufficient by itself to constitute culpable negligence or recklessness. In order for you to include a violation of any of these rules in your deliberations, you must also find that such a violation was accompanied by a thoughtless disregard of consequences or an indifference to the safety of others and caused or contributed to the cause of Luciana Cristina Fernandez. And I think that kind of bridges the gap between telling the jury just to ignore the navigational rules, which of course can't be done in any scenario, including when we're talking about court proceedings, but it also does not make the mere violation of those rules in and of itself per se reckless or culpable negligence.
Well, but the violation of the navigational rules, they're designated as non-criminal infractions or careless operations or simple negligence.
Right, just like running a stop sign is not criminal, it's an infraction. But certainly if we were trying a vehicular homicide case and part of the recklessness of the driver was that he or she ran a stop sign, is the state not allowed to talk about the fact that the person ran a stop sign? If you ran a stop sign and that proximately caused the death, in addition to other factors, the jury should be allowed to take into account the fact that the person ran a stop sign.
Yeah, I mean, again, you have to still prove the higher threshold of the culpable negligence or recklessness, and the jury has to understand that that is your burden and responsibility.
Of course, but that's why this instruction that I've crafted says a violation of any of these rules is not sufficient by itself to constitute culpable negligence or recklessness. So the court is advising the jury, you can't find him guilty just because he's violated navigational rules, but it should be a factor to take into account.
It can be a factor.
Yes, and in order for you to include a violation in your deliberations, you must also find that it was accompanied by a thoughtless disregard of consequences or an indifference to safety of others and caused or contributed to the cause of, in this case, Lucy Fernandez.
So a couple things. First, I think we may be in a better position just to give just a vanilla instruction without getting into the elements of recklessness and or culpable negligence.
I thought for purposes of the witness testimony, this, what you're describing here, and I was working on it also this week as everyone else, I think has the basic principles. Why don't we craft something that perhaps is a little more basic that I can instruct the jury on? So, you have a suggestion?
The state's suggestion would be that perhaps prior to Mr. Albert testifying, the court advised the jurors that they may hear testimony about navigational rules. The violation of any navigational rule by itself does not constitute recklessness nor culpable negligence.
And it's I can maybe include they're explicitly designated as non-criminal infractions.
Why do they need to know that?
May hear testimony about navigational rules, the violation of the navigational rule.
A violation of navigational rule or rules does not by itself constitute recklessness nor culpable negligence. I think that puts it into context. It's simple, it's straightforward, it's an accurate statement of the law, and it limits the jurors from thinking, oh my goodness, we are now hearing what these navigational rules are. We're seeing with our eyes evidence that substantiates that the defendant may have violated those rules, ergo he's automatically guilty. This keeps them from doing that.
It should also be clear, given the case law at Logan, that even a violation of the navigational rule does not necessarily establish negligence. You can violate a rule without putting anybody in danger. So, for example,
I don't know if that's,
yeah, it's not every time. Not every time, for example, to use the. So not every failure of a rule will cause a breach of a duty of care to another person, because that's what typically these rules are designed to do. Let's say a safe speed. If you exceed the speed limit by 1 mile per hour, that's not necessarily negligent, because if 35 miles per hour doesn't constitute.
that it wouldn't rise to the level even of a simple negligence.
Correct.
To that end, Judge, the defendant is not charged with any offense that negligence is the standard for. The defendant is charged with conduct that would either be reckless and or culpably negligent. So bringing in negligence of itself is really not pertinent to the charges that the defendant is facing. So
Well, are there any, ultimately, I don't know if there are any lessons that would be instructed on in this case.
Well, that's still something to be decided once we hear the testimony, because
Well, that also, that, you know, yeah, why would I be bringing in simple negligence?
because the word culpable negligence sounds a lot to a jury like negligence, and they need to understand there's degrees of negligence,
Okay.
and that a violation of the rule may
A
not
higher
even rise.
threshold. It's a higher threshold of evidence.
Correct, but even the basic rule violation may not be conclusive of negligence. Like I just said, 36 miles an hour in a 35 zone is not necessarily negligent, because some rules are enforced based on public policy, but not necessarily evincing a disregard of the care of someone else. Otherwise, you get the point.
I made her testimony about navigational rules. The violation of navigational rules does not,
in and of itself, constitute recklessness.
and or culpable negligence.
I would say recklessness and or culpable negligence.
And so my request would be to add,
Hold on, I'm gonna add something.
so a violation of a navigational rule is not conclusive evidence of even ordinary negligence.
Okay.
I thought we were trying to simplify this. Why are we bringing into this trial a standard that is not what is charged? It makes it more confusing. We're not talking about if he's negligent or not. I would suggest as an alternative to that the court consider something along the lines of any alleged violation of or any possible navigational rule violation is only one factor to take into account in determining whether the defendant was reckless or culpably negligent. But otherwise, I just think it's more than sufficient to tell the jurors that this is a violation of a navigational rule or even violation of multiple navigational rules does not in and of itself constitute reckless or culpably negligent behavior. It just seems like the most basic, simple way to explain it to a jury, and certainly we can flesh that out more in the final instructions that the court gives. But for the purposes of giving the jurors a heads up of how to interpret the testimony they're about to hear, it's an accurate statement of the law.
You know what, I'm comfortable just with the simple sentence there, and then in the final instructions, there's going to be more explanation about, and it will depend on whether there's going to be any lessers requested. Any lessers requested as well, it's going to depend on that as well. So I think that I'm going to wait for any further conversation, that any of the detail, I don't want to confuse the jury, and I think that's simple enough not to mislead them as well.
One more moment. So, Judge, we understand you've overruled our request, and we'll, I guess, readdress this at the final instruction phase.
Of course.
And I don't know how long Mr. Albert will be testifying on direct, but I would request that when he's done, we could take a break then,
Of course.
so I can confer with our expert.
Absolutely.
Thank you, Judge.
Okay. So, I think that was the only matter before the witness comes in.